Good evening, everyone. A very warm welcome to all of you who have joined us today for the session under the IIDRC ADR across industry series. Now, it is truly an honor to be here and to have the opportunity to share the dice with this wonderfully curated panel. I would like to move on to the topic of today's session, that is why sectorial expertise matter for modern dispute resolutions. So, as we all know, the disputes we see today are very different from the disputes of even 10 years ago. Industries such as technology, energy, construction, telecom, finance, mining, sports, arts, etc., are now with a level of detail and complexity that requires a deeper understanding how these sectors function in real life. When arbitrators or counsels do not have this background, proceedings often take longer and evidence become harder to interpret. Sometimes, even though the legal reasoning may be sound, but the final decision may miss the practical and commercial reality of the dispute. This is precisely why arbitration has always been valued as a dispute resolution mechanism. Unlike courts, arbitration allow parties to freedom to choose decision makers and understand the industry rather than relying on a generalistic approach. Parties often structure their arbitration clauses to reflect this, and whether by prescribing qualification of the sole arbitrator or by opting three-member tribunal where the technical and commercial expertise can be balanced with the legal experience. This flexibility also ensures that complex disputes are decided by those who do not need to be taught the basics of the industries from scratch. Now, globally, we are already seeing this play out in a structured manner. Many arbitration institutions now maintain a specialized panel or rosters, such as maritime disputes are often resolved under the bodies like London Arbitrators Association or the Singapore Maritime Association or of arbitration. For the construction disputes, these are frequently handled by the arbitrators with engineering or product management background. Moving to the intellectual property disputes often go before the institutions such as WIPO, which understand the which has a technical understanding of this particular industry. These specialized framework allow tribunals to grasp the issue faster, reduce unnecessary delays, and often deliver more commercially sensible outcomes. Now, India is also gradually moving towards this direction. While Indian law do not have mandated this sector-specific qualification of arbitrators, court have already recognized the value of the expertise. The Supreme Court has acknowledged that technical knowledge does not undermine neutrality and that excludes experienced expert would be in fact weaken the arbitration. As disputes has become more complex and India takes a greater role in cross-border and investment-related matters, the need of arbitrator, the need for the arbitrators who understand this industry practices, policy implications, and technical evidence has become more critical now. So, when we speak about the sectorial expertise today, we are not suggesting the departure of the legal principles. What we are truly talking about here is to strengthen the arbitration by ensuring the legal reasoning is informed by a commercial reality, technical understanding, and global best practices. Now, to speak more on these topical issues, I would please to introduce a panel of eminent speaker who will enrich our discussion with their intellect. So, our first speaker is Mr. Gohar Mirza, who is a partner at Sarraf and Partners. Sir is widely recognized for his work in technology law and commercial arbitrations. He has successfully handled high value disputes for both private and public sector clients across infrastructures, real estates, partnerships, and regulatory matters. He has appeared as an arbitrator uh, under SIAC, ICC, and as a counsel also under LCIA and ICA rules. His ability to navigate these disputes involving fast moving industries makes his perspective very important for our discussion today. So, sir, it is an honor to have you with us today, sir.
Thank you, Akash.
So moving next, our next speaker is Mr. Nitin Gupta, who is a partner at Asia Law Offices. Mr. Gupta has bring more than 2 decades of experience in constitutional, commercial, and corporate matters. He regularly appears before Supreme Court and High Court and serves as an arbitrator in the panel of IIAC, DIAC, MCIA, and ICA. Also in the several other institutions which I'm not aware of. So his work spans energy, construction, telecom, manufacturing, and healthcare, which I think which we need in our today's discussion. He understands both the legal and practical sides of disputes. So, sir, we are delighted to have you here, sir. It's pleasure to have you here, sir.
Thank you, Akash. I hope everybody can see me. I can't see my own video though.
Oh, I think so. You're visible.
I'm visible. All right. Thank you. Thank you, everyone. Hi, Gohar. Hi, everybody else on the panel.
Hi, Nitin. Welcome.
Hi.
Hi.
Thank you. Thank you.
So our next speaker is Ms. Surbhi Lal. She is a principal associate at Shardul Amarchand Mangaldas. Ma'am specializes in international and domestic arbitration, commercial litigations, and mediation. She has represented clients before Supreme Court and various high courts, and also includes the leading institutions such as SIAC, JCAA, ICDR, and ICC. Ma'am is also active in teaching and mentoring young lawyers like me. We are truly looking forward to your perspective, ma'am, in today's topic.
That was too kind. Thank you, Akash.
Thank you, ma'am. Thank you. And we finally have with us Mr. Shravan Yamanur, who is a partner at Denton's Link Legal. Sir has an extensive experience in international arbitration, public international law, trade law, and more importantly, investment treaty matters. He has advised the government of India in treaty negotiations and has represented state in major industrial state disputes across mining, oil and gas, energy, and aviation. So his deep understanding to policy, economics, and sector dynamics allows him to bring a unique perspective on the expertise which India needs as it deals with more complex disputes in the global arena. So, sir, it's I am delighted to have you on this panel, sir. It's glad to have you here with us.
Thank you so much, and hello to all the panelists and the participants. Good to see everyone.
Thank you, sir. Now, I would request Mr. Gohar Mirza to give his opening remark on today's theme, that is why sectorial industries are required for the modern dispute resolutions.
Yeah, thank you, Akash. So I know it's an interesting topic, and we have been speaking and discussing this at different forums. The specialization on a tribunal is very important for 2-3 aspects, according to me. And there was a question I think you had circulated earlier before we could start speaking, is that what can get missed by an arbitral tribunal if there is no expert on the panel? I think what can get missed and what can get ignored is the quality of the breach, the issue with respect to delay assessments, etc., and also quantum. So if you don't have an expert on the field, or a person who doesn't have the experience or knowledge of what exactly would have happened, because arbitration, when it is happening, the proceedings when they are happening, they are in present time. The dispute happened 5 years ago or 3 years ago or 2 years ago. The contracts that we see that come into disputes is after 7-8 years, when the the defect liability period expires, etc. So we take a range of at least 5 to 7 years when the actual issue may have erupted or may have come up. Nobody can go back in time and find out what exactly happened. But when there is an expert on the panel, or when there is an expert on the tribunal which is adjudicating the dispute, it always helps if the person has the ground knowledge. I'll give you a very small example that whatever construction arbitrations we do, at least domestic, I actually send my team or I go myself to visit the project to see exactly what the issues are. There are multiple issues with respect to soil erosion, with respect to rock classification, etc., which are very complicated. Obviously, I'm not very sure the experience of the audience that we have, but these are issues which only an expert can understand. So usually what we see and what we importantly ensure is that there are two experts on the panel, and one can be either a judicial member or an ex-judge or a Supreme Court or a High Court retired judge, who can then place the sense of justice between two parties, the concept of breach. Because on paper, a few things may look very, very different. I'll give you a very, very small example. Recently, I was doing an arbitration, construction arbitration, which had a interstate tax related issue. We did not have on the tribunal a tax expert or a person who can understand the exchange of documentation on a interstate basis. So all the three members of the tribunal got absolutely confused as to what exactly was the process, and they had to actually invoke 27 and appoint an expert in taxation. And then the other side, which was the claimant, we were representing the respondent, they brought an expert of themselves, and then we were also prompted to get an expert on ourselves to understand the procedure of taxation, or on exactly what happens when goods are exchanged on at a interstate basis. So those are a few issues that I can point out that I have seen, at least, that if you don't have an expert, you really cannot decide as to what exactly was the breach. Once you can't decide exactly what is the nature of the breach, if there is an issue of delay, you can't decide that. And then ultimately, the ultimate issue that arises with the absence of an expert on a panel would be quantification. The extent of how a tribunal sees the breaches ultimately gets converted into how the quantum is decided. So I think that is exactly what is the requirement or need. I only speak whenever I speak on practical basis. We hear people talking on academic basis also, but I think the basic difference that we understand between academics and practicality is exactly what we see, that in law school, what we read in our books is very different from what we actually do in court. So my perspective exactly is that when you actually have a person who knows practicalities of things, that those are the best people to understand and make you understand where the breach exactly is coming in from.
Thank you so much, sir. Thank you. I would now request Mr. Nitin Gupta to give his opening remarks, sir. Over to you, sir.
Well, I think half of the things Gohar has covered, I wanted to cover up that in construction, but I think he's covered it relatively well. It is absolutely right and important that, one visits the site, be it any EPC contract, be it any contract for any road construction or any other construction, need not be only building, could be other things also. So it is imperative that you understand the nuances involved. And construction law, no doubt, is a very, very complicated situation. You have your EPC contracts. It could be a turnkey contract. There could be the principles of delay, EOT, extension of time, which triggers your liquidated damages. There could be concurrent delays, critical path methods, program evaluation and review techniques. And obviously, if somebody is not aware of how a construction, because every delay is not technically a delay. It is possible that, some delays were bound to happen. Some delays are beyond your control, or beyond the party's control. Could be the contractor, could be the subcontractor, could be. So that is, these nuances are very important to realize in a construction contract. Unfortunately, without quoting the judge, a retired judge of Supreme Court, I heard him say at one of these construction law conferences that I cannot ask the rest of the retired judges to learn construction law. They have been they've been passing judgments for the last 30 years, which I thought was a very, very, very inappropriate remark. Because we also as lawyers and we also as arbitrators have faced difficulty. It's not that we as lawyers, Gohar or me or maybe Surbi and the rest, we are also not experts at everything. We are experts technically at law. So for us also to understand this is equally important as it is for judges. The only unfortunate part about India is here we really want a retired judge to be an arbitrator, and we are very reluctant on having an expert or an expert from the industry to come in as an arbitrator. So, if as a lawyer, if if the other side has appointed a Supreme Court retired judge or a High Court retired judge, my client will just not agree to having an expert on the board from the industry. They'll also insist on having a Supreme Court retired judge or a High Court retired judge. But the problem is first of all, it is very difficult to explain it to the tribunal how the entire thing has to work, how the entire contract must have gone through. I do not know. I have not personally dealt with the situation where the tribunal agreed to go to the site and to see actually how things worked. I don't know. Gohar can probably answer this better. Has he had experience where the tribunal, in their wisdom, decided to visit the site also? Or they wanted everything to be shown in the room where they were deciding on all the legal terms and all the delays and everything and listening to the experts and hot tubbing and all that stuff. So Gohar can answer this better. Over to Gohar for this.
I think Nitin, you're absolutely right and bang on. Rather, 1 year back, there was an arbitration that was happening. We made an application actually for the tribunal to visit, and the obviously the reluctance was absolutely visible. And ultimately, one of the members agreed, who was actually the technical member and who had seen that terrain. That member agreed, but the other two did not. One giving the excuse of age. Second, obviously, that the mandate or the fees that was decided to be borne by the parties does not cover this. So there has to be a special fee, etc. So I think those are practical problems that we have seen in my 15 years of my career. I have never seen a tribunal visiting the site, whether it's domestic or international. So that's my experience at least.
I won't take more time on this. I think over to the next speaker. Otherwise, the topics are too many and I will take up everybody's time.
No, sir. It's
You
fine.
are currently not visible to us, I guess.
I'm sorry?
You are currently not visible to us. And may I kindly request to all participants to turn on their camera so we can make this session a little bit more interactive.
So I was wondering why I'm not visible because I can reconnect again.
Yes, okay, Dosa.
Okay, I'll reconnect again.
So we'll wait for 2 minutes. Let's join and then we can convene again.
I guess you can continue. Akash has put his point on the opening remarks.
I think that was a wonderful example of what practical experience we deal in today's era of specific sector expertise. Now I will turn to Ms. Survi ma'am to give his opening remark.
Thank you so much. First of all, 2 points from what Gohar said and what Mr. Gupta said. Gohar mentioned about how, these cases are 5 years, 10 years old. And, actually I'm doing a case right now, where the agreement was executed 7 years before I was born. So it is so difficult for us if we do not look for sectoral experts. It is so difficult to establish what the intention of the parties was qua a particular clause, that it is impossible to prove the breach that he is talking about. Because me sitting in 2025, it is so difficult for me to think about 1984 and rather than thinking and understanding, to establish something. So from that perspective, the sectoral expertise requirement of understanding, it's a very simple point, understanding like things like at that time land area was measured in bigha or acres. We are struggling with that. So we are looking, so even these small points and with the respect to time, it really matters. So that's something I picked on, and I think I would wanted to expand. And second, what Mr. Gupta mentioned, and was a very critical point about the reluctance of the tribunal to visit actually the site, and that also helps a lot in understanding the background of the matter. For the past 8-9 years, I have had only one case where I actually, without any application, the tribunal agreed and wanted to visit, and that was because it was a pharmaceutical dispute, and the tribunal was keen on understanding the process of pharmaceutical manufacturing because it was so technical in nature that to understand where has there been a breach, where was sterility failure happened, how does it was necessary for them. So but But as Mr. Gupta pointed out, none of the members on that tribunal were Indian, and none of them were judges. So that is one factor, maybe that could have led to this. So I wanted to highlight these 2 points. And Akash, when I think about this topic, actually I was thinking about in the morning how to formulate my thoughts best. I have 6 points that came to my mind, and I will quickly talk about that. The first thing that comes to my mind when you talk about why sectoral expertise matters is number one, efficiency. If you have a counsel who has worked on hotel management disputes, who has worked, as Gohar pointed out, so many examples of a construction dispute, energy disputes. The moment I go and I read that contract, if I have worked on something like that, it's easier for me to understand the background facts. And the more up to date you are with the facts, the better you'll be able to assess and come up with grounds for your client. So yes, in my opinion, it does matter to have known how hospitality works or how a power plant works, how is this O&M operator conducting himself. That it comes in from there. First point, efficiency. Same efficiency translates into my second point, which is enhanced decision quality. If you as a party and with your counsel's assistance appoint tribunal members who have the same sectoral expertise, that makes life so much simpler for that arbitration to go over. If you choose an arbitrator who has done X number of disputes in the past, it really helps in a smooth transition of your arbitration. There will be lesser requirement of experts, more better understanding of what is required, what is the standard of proof required for establishment of that breach. So because in such matters, as he pointed out, breach establishing it often hinges on these technical details. So this knowledge directly translates into the strength of our tribunal to analyze the evidence. And as we all know, the admissibility and relevance of an evidence and that decision lies solely with the tribunal. So that becomes very critical. Next, I've also thought about this topic from the lens of a client, credibility and trust from that perspective. If you think, if your counsel, if your tribunal is someone who has that sectoral expertise, it gives a party more, I would say, sort of comfort in the sense that, there's a cooperative environment in which my arbitration is proceeding. It gives a sense of trust in that matter. The next thing that comes to my mind is a very targeted and innovative solution-based approach. I did a arbitration where from my arbitration, I went into an expert determination because one aspect of that matter was so technical, how a budget of a restaurant is to be run and decided for the future years. And the tribunal, they were not chartered accountants or CFA qualified professionals. So then we got an opportunity to look into expert determination, which was a much more technical process. So it helps come up with innovative solutions also if you are more better prepared in understanding the sector that you are looking at. The last point, as you have covered in your point, the maritime law. It is so niche that recently we were looking for maritime law experts, and we realized that the people to be appointed on a panel with maritime law expertise is a very narrow field of professionals. So yes, these are the key points that come to my mind, and I hope they assist you. You ponder over them, and I'm happy to answer any more questions.
Sure. Thank you so much, ma'am. Thank you. I think most of my whatever question I had to ask, you have covered most of it. So now I'll move on to Shravan sir. Over to you, sir, for your opening remarks.
Thank you so much. And it's interesting to be the last speaker at times because there's very little you can say to better such eminent words that are coming. But I think the takeaway from the discussion so far for me is that I don't have to convince you that sectoral expertise matters. I think we are quite unanimous here, as you can see, that clearly we need to consider, however, when we say sectoral expertise, I think there are facets to it, and some of it came about in this discussion. So you can have a sectoral expert who is sitting as an arbitrator in the process. You have sectoral experts who can act as counsel or assist the counsel team. And then, of course, we have sectoral experts who are appointed as party appointed experts or independent experts, even appointed by the tribunal to assist them. And we often see this in international arbitration. I think that is quite standardized now. The real question is, in India, are we seeing that happening? Because while, I'm sure the other speakers who have several years of experience in international arbitration, they were talking about construction arbitration. There is a lot of value in having naturally, experts of that field as arbitrators. And we see that there were examples discussed: maritime law, construction disputes, etc. And it's happening internationally. It is happening. You see bodies created. So, for example, there is because I've interacted with them. There's a Royal Institute of Chartered Surveyors in the UK. So they have a panel which is created for construction disputes. So they have mediators, they have arbitrators. I'm just giving an example. So similarly, you have so therefore there are institutions as well who focus on certain sectoral disputes globally. We're seeing that now in India as well. And so in this multi-layered process that is there, I think there is no doubt that sectoral expertise matters. We all know the basic saying that practice maketh man perfect. And therefore, and that naturally means that as one gains experience in a certain sector, they will be in a position to better contribute. Now, I'll give some perspective that I have from investor state disputes, and specifically also dealing with oil and gas disputes. These are quite technical areas, right? While investor state disputes, of course, involve more of public international law and involve a public law element. So therefore, there you may see less of a need of commercial sectors or technical experts, is what you would think. But it's not the case. Along with the importance of public international law, because it involves commercial aspects, I have found that you always see engineers, you see experts being brought in even in investor state. I'll give you an example. We were handling a certain investor state dispute. Now, in that, the dispute was concerning a certain mining lease that was cancelled by the government. Now, when it came to valuation of the damages, we had a valuation expert, and basis the discussion, we realized we also need a roads expert. Now, you'll wonder, why do we need a roads expert when the dispute involves mines and we are talking about investor state? But during the discussion, it emerged that in fact, to determine the causation and to determine what mitigation steps have been taken by the other side, they needed to actually establish roads all the way to the mine. Now, without expansion of the roads, the trucks that were coming from the mine would not be able to actually go through, and the value that they were claiming would not be achieved. Now, you see, this is quite unique. So even though it's a mining dispute, you would think I need a mining expert, naturally. But then on top of that, we found value in having a road expert who explained that the roads currently leading to the mine and to the plant were insufficient. And there, significant investment would be required by the investor to actually expand those roads. And it was an obligation that the investor had. I'm just trying to tell you that experts, therefore, have a lot of value. And of course, both sides ended up having party appointed experts. Once one side, of course, realized this and appointed a roads expert. The other side naturally said, I would like to respond to it. They got their own expert. So while you address this through the form of independent experts, there is no doubt that having expertise on the arbitration panel itself would be very helpful, because during the deliberations that the tribunal has, which we are not privy to, having someone with certain expertise would be really useful and would carry a lot of weight in those discussions. So I think these are very important. And I'll end with this. Investor state disputes, you would think the counsels know public international law. The tribunal members usually are people who have experienced in public international law. But even in those disputes, parties do end up appointing experts in public international law, because even within public international law, there are such expertise that is required in certain specific areas, whether say it is space law or say the law of seas, that you may want to appoint someone to assist the tribunal. And we see this often. I'll end it at that, and thank you so much for giving the opportunity once again.
Thank you, Shravan sir. It was so much interactive and insightful that because it is in the case of investor state disputes, like including me, I'm not very much well versed with this fact, but like you said, we need the sectoral expertise to analyze and to deal with all these uh, sectors and industries to understand what outcome can come. So with this, I would like to move on to the questionnaire which I had prepared to ask you. I think I'll start with Gohar sir, but Gohar sir has already covered most of my questionnaire in his opening remark. So I'll keep it very short. So now the question is for Gohar sir. So what part of the dispute becomes most vulnerable when the arbitrator does not have enough familiarity with the industry? Like you already pointed out, I just needed what changes does it make when the arbitrator do not have familiarity with the industry?
I
Over
think
to you.
Akash had mentioned earlier, I think the most important is the quantum decision on quantum, becomes the most important and the most complicated issue, because breach can be established by way of understanding whether party followed the contract or not. But when it comes to quantum, if you're not an expert, you will not understand that a small breach can actually lead to a bigger quantum, and a very big breach which appears very big on a paper, on a page, on written, but actually had no impact and was actually practically required. So I'll give that also with an example. I was doing a tunnel related construction arbitration where we had a technical member, a non-technical, and a judge of the retired judge of the Supreme Court, Honorable Supreme Court, where blasting is one technique which is used when a tunnel is prepared blasting is a controlled blasting, and that's the process that they follow. So there is a term called controlled blasting and a term called magazine, which the explosive that is used. So the non-technical member actually thought that it's such a big issue with respect to security, etc., etc. This should never have been done. But a technical member had to actually explain that how a controlled blasting is done and how we have to actually understand it's a daily routine, a daily work that is required for building of a tunnel. So those are few things that, and ultimately when we saw the award, it was in my favor against the claimant. But we saw that although I won the matter and the matter is presently before the High Court in a 34, but I could understand the lack of knowledge of the project and the lack of knowledge of these small terms and usages that are actually required at the time of the project is what affects the parties ultimately. That party lost the arbitration, it's a zero award. They got nothing. They claimed a lot, they got nothing. So I have all my sympathies to the other side. I won, I proved that how there was no loss otherwise. But I could also understand, being a lawyer, being somebody who does construction arbitration on a daily basis, that how frustrating it is for somebody to explain to a tribunal or a member of the tribunal that something which is very normal for a project, for a site at that point of time, can't be blown out of proportion and written in an award. So I think that's my take on it.
Correct. I think that might be also the reason, like why we are not currently doing the expeditious disposal of the arbitration matters. If the observation would have been given on that particular expertise, then I think this matter would not have been challenged under Section 34. But as we see,
that is a very different discussion that you can have separately. That every award gets challenged in 34. Nitin, Shravan, and Survi will know that any award that comes to us, I remember, and I say this every time as a matter of a joke, that once a client came to me, showed me an award, and I told them it's a perfect award. Please don't challenge it. Please play. They went to some other law firm, and the other law firm filed the 34. So that's what exactly happens. That's the practical reality we live in. So any award that comes, you have to understand that it will go to 34. A challenge has to be made. Foreign awards, I'll tell you examples of foreign awards. Indian parties in international commercial arbitration, if it comes there, they go to Singapore, they will go to London courts to challenge it. They will fail. And when we enforce it here, they will object here also. So everybody wants to challenge it. So I don't know if it's a litigant's world or a lawyer's world. We are yet to see.
So I have seen, like, I have read it somewhere that in Singapore, usually the arbitration matter get concludes with the finality of the award in 3.5 to 4 years, max to max. But in India, on an average, it takes like 13 to 14 years to conclude and attain the finality of the award, sir. And I think having non-experts on the sectorial or industries, this will make more vulnerable. India will be becoming more vulnerable on these, and it will expand. And the expeditious disposal, we will not be able to attain that particular expeditious disposal of the matter.
That's
Now,
correct.
correct, sir. Now I'll move on to Nitin, sir. I think he has also like covered most of the uh, questions into his opening remark. So I'll keep it very short. What stage do you most often see an arbitrator usually derail due to this gap in understanding the sectorial expertise? If I'll take an example, let's say in energy sector, what do you think, like, when the arbitrator do not have the experience of the energy sector, where do he fail to analyze or understand, and he passes the award, and because of that this
I'll rather put it in a different way.
right, sir.
You see, the problem with arbitration is that by way of 34 and 37, it is very restrictive, and I think that's something which is worldwide. It's not only in India.
Correct.
Now, choosing an arbitral tribunal becomes very, very important, because if they do not understand the sector, they do not understand the nuances, they do not understand how that sector works, it becomes increasingly difficult. I can give you an example where this was a simple commercial contract, construction related. Air conditioning had to be provided in the metros.
Okay.
We, as a law firm, decided to have our nominee who was a former chairman of Indian Oil. The other side decided to have a lawyer.
Okay.
And the umpire which was chosen was former chairman of ONGC. So technically, they had no idea of air conditioning, but it was a commercial contract.
Right.
It was a contract based on whether the supply was made, whether it was received, and what are the deductions. So, commercial knowledge is also very important, which,
Right.
pardon me saying this, some of our judges don't realize that. They get too much into law.
Correct.
You have to also understand the commercial part of it. I know you are bound by the contract and you can't go beyond the four walls of the contract, but sometimes the practical aspects are very important. I can give you another example of an arbitration which was the venue and seat was Singapore, but the law was Indian law.
Okay.
Now, so the tribunal holds that yes, there is definitely breach, but you have not been able to prove any damages. Now, that's, according to me, against the Indian Contract Act. If there is a breach, there has to be some damages.
Correct.
Interestingly, the client goes to Singapore High Court. So High Court says, my sympathies with you, but I'm sorry, you chose the arbitral tribunal.
Right.
I will not interfere in 34 or whatever section is applicable in Singapore. So choosing the tribunal is very, very important, because they need to understand not only, now there was a problem of law.
Right.
The Singapore example I gave you, I don't think that had got anything to do with sector specific thing. But yes, it is very important that, otherwise we were really struggling with the tribunal to make them understand. I think in India, the norm is pretty much set now that you will have all judicial members, either sides, nominees, and the umpire would be the same, and keep bringing in experts as and when you feel like, and the cost of arbitration skyrockets. I have had clients, I have had people saying money is not a problem. Unfortunately, those are not my clients, but I have had people say who are in the sector say that money is never a problem. We'll get our money back. So choosing an arbitral tribunal becomes important to that extent that you are not wasting too much time. Thankfully, there have been changes in the act, and now there is a bit of restriction, but I don't think it is you really need somebody for the from that sector to understand it better. Otherwise, everybody is happy. We as lawyers are very happy. There is arbitral tribunal. There's fees there. We go in 34. There's fee there. We go in 37. Unfortunately, that metro case, even in curative, you can get something. So I mean, it's a never-ending proposition.
Correct, sir. I think that suffices more, and I think that can also lead to our any other session which we need to be which we need to do, that is on the operational realities versus the contract wording, like you rightly said, that everything, no one can go beyond the contractual aspects, but
Yeah,
in
but I don't think any of the speakers will agree with me. Personally, I feel 34 should be an appeal.
right, sir.
But that's my personal view. That's not the firm's view also.
Like we have it in Singapore, sir. Like there is only one appeal, and because in Singapore we have this New York Convention which binds the finality of the award, but the same is not the case of India. I think that is also one reason of this.
With the limited scope of 34, personally, my personal view is it should be treated as an appeal, as good as a civil suit or a commercial suit being decided, and everything should be questionable in an appeal, except making the payment at one go of the entire amount.
Correct.
Which is also common for both.
Right. So thank you so much, sir. Thank you. I think that has covered a lot of areas of our topic. Like it has given an overview, and it has also given a more opportunity to have another session on these subject topics which you have just provided us. I think I'll now move on to Surbhi ma'am, and Surbhi ma'am has also given most of my questions answer in his opening remark, but still I'll ask one small question, that what are the most effective ways, although ma'am has given the pointers of the efficiency and everything, but still I'll ask that what is the most effective way that ma'am has found that helps the tribunal to understand the technical background of the complex disputes, besides the efficiency and other part. What is the that advocacy technique and communication challenge that one as a counsel face to make the arbitrator understand the technical aspects of the industries?
Thanks, Akash. First, I'll agree with Mr. Gupta that you look at the background of your arbitrator before choosing an arbitrator. Then you will not land up in that problem. And that is something that I have actively done in the arbitrations, that we genuinely look for, and we look for similar experience, similar background, and then go for appointment when it is possible. Obviously, if it's a Section 11 appointment, that's a different thing. But in international arbitrations, wherever it is in our hands, look for a nominee that has done hospitality, pharmaceutical, energy, whatever is the dispute, but you will always find such sectoral expertise. It is important and will help avert this question that we are now facing. But we are not very efficient people in this community, and with clients also, sometimes this doesn't happen. So, what I feel has been an effective way generally, obviously, as we have been talking about, either party appointed experts or tribunal appointed experts, but last year, I did one arbitration. It was an oil and gas arbitration against a public sector unit. What we did was that we realized that there were issues about, there are two types of drilling, horizontal and vertical. We realized that certain basic concepts that we in our pleadings, because we were also so engrossed in the matter that we used to use phrases and concepts just out of the blue, that vertical alignment happened or horizontal drilling required this, that we realized that actually there's a requirement of an expert who's not even like an expert, but somebody who explains the practicalities of these terms to the tribunal. And what we went for was not a technical expert in that sense, but we took a factual witness. So the person was an engineer in the organization, and we file witness statements, and the person explains the facts. This is what happened, this letter was sent, this is how the letter, this is what we responded. But what we went was a technical factual witness. And what that helped was, because the person had both the technical qualification in that sector plus the practicalities of how he actually did the transaction, so he could link that very well. The basic concepts he could link very well for the tribunal in that matter. And we thought that it laid the groundwork for us for our final argument, so that the tribunal is more prepared to understand those basic concepts when we mingle them with our facts. So that is something that it was unique, because I had never gone with a technical factual witness before. Generally the witnesses had been very much concentrated on the facts that we've already pleaded, and supporting them in that sense, helping me establish that. That is something that comes to my mind to answer your question. Other than that, it's always been expert witnesses. You can have reply to those experts. And generally in international arbitrations, we see then there is also a joint expert report. So that really helps a tribunal narrow down these technical issues, because a joint expert report is both the points that they agree upon and the points that they do not agree upon. So the points of satisfaction and dissatisfaction. To the extent the points of satisfaction are culled out, it's very easy to decide these claims are out. And this has recently happened in another pharmaceutical-based arbitration. So it was easy to understand. Okay, sterility testing or something. We can see if there's an agreement between the parties. So from that perspective, these two techniques, either a technical guy from the organization helping make that link with the facts and the technical expertise, explaining the concepts to the tribunal. Secondly, if you're going with an expert, then you complete the process. Expert, reply expert, and having a joint expert, I really see merit in that.
Correct. I think that suffices more that either you have the arbitrator who has a sectorial expertise, or you bring a witness who give you the technical.
Can I ask Surbi a question?
Sure, sir, please.
So Surbi, this gentleman whosoever you're talking about was throughout there in the arbitration, or during the argument stage, or only the witness stage, statement stage?
He came in as a witness. We took him as a witness, a factual witness, but a factual technical witness, and then he deposed in the arbitration.
Because in one of my arbitrations, we had somebody from the organization also argue a 17.
Argue it?
On the technical aspect. Because again, though there were technical aspects which were required and the tribunal allowed that.
That's pretty interesting. Yeah.
So probably this could also be something which the tribunals can consider, that that a person other than a lawyer can also explain it slightly better to the tribunal.
Right.
Agreed. Fully agreed on that.
I think this also explains why we need the sectorial expertise arbitrators to understand the basic consequences and the background of the technical aspects of the industries. And we should not because if we'll call the witnesses, then it will again take more time, and it will and India again will lack to not expeditious disposal of the matters, as India is already backing, on an average India takes 13 years or 12 years to attain the finality of the award and the execution of the award. So with that, Shurbi ma'am, I think that suffices the answer to my question. Now I'll move on to Shravan sir. Sir, I'll keep it short. Again, the question is, which area of expertise specifically do you believe India need to strengthen? I'll be more India specific now. Strengthen the most in order to handle the investor-state dispute more effectively. Yes. Over to you, sir.
Yeah, I think I'd seen the question that you had
circulated as well. I think you had divided it into four, if I understand rightly. Trying to recall policy, economic analysis, and sector knowledge, TT interpretation. But see, I think credit has to be given to India as well. I understand the sentiment, Akash, but I believe that there's been significant progress that India has made, right? Whether it's in commercial arbitration, perhaps, initially when there was a statutory time period or limit that has been now created, which is quite unique globally. If you see, I don't think there's any other regime that has that now. So there have been statutory answers to it. I think the court is also regularly intervening to make sure that the course is set right wherever things go wrong. So there's no doubt there's much progress required. I was attending an IBA event, and I believe the talk was that we have the most number of lawyers in the world. Now, we're of course the most populous in the world, but also we have the most number of lawyers in the world. But perhaps not the most number of judges, which is surprising. Therein lies the answer to these things. I just wanted to uh, point out that there is progress. I wouldn't want to paint a very dark picture of the Indian arbitration landscape here. Second, as far as your question is concerning regarding ISDS, my takeaway is that there is no lack of expertise in terms of treaty interpretation or policy making. Having had the opportunity to sit in those treaty negotiations, having worked in the government of India for a while, I can tell you that we have some very scholarly people there in the room, and people who understand public international law, have been regularly negotiating these treaties for a long time. And in fact, the India's model BIT as well, you may hear a lot of criticism about it, and there's no doubt scope for that. And as a democratic country, I mean, that's the beauty of it. We can do it, and we should. But at the same time, it has actually inspired many other countries to also reconsider. And if we see globally, also there is the UNCITRAL discussions that are happening regarding ISDS reform. So reform is the key word now across the globe as far as these kind of disputes are concerned. And India has in fact taken a very, a lead in reform. Yes, maybe the pendulum has swung on the to one way currently, and maybe there can be a balancing act which we see in the future. But the point is that yes, I don't think there is any dearth of treaty interpretation or policy understanding as far as that is concerned. We do have experts. We have people in the Department of Legal Affairs, in the Ministry of External Affairs, the Ministry of Finance, who are specifically dealing with this, and who are, I would say, some of the leading experts, in fact. But now coming back to our topic here, and I think which is more relevant, is sectoral knowledge again.
Correct.
Right? It becomes important, and no doubt India, as far as I wouldn't say ISDS is a sector, because it's more of a branch of law, but yes, within ISDS you'll see that there can be cross-sectoral disputes. So you'll have oil and gas disputes, which are also an ISDS dispute. You'll have a mining dispute, which is also an ISDS dispute. You can have a completely commercial dispute, say a shareholder dispute. Even that can be converted into investor-state dispute as long as state action is involved. So if there is a foreign investor and state action is involved, you'll find that so there are all these sectors which are under the umbrella of an investor-state dispute. And there, like I had already said, it is commonplace that the tribunals utilize services of experts. The parties do too, right? And you do find that tribunals use that as well. Now, for example, let me just take a oil and gas PSC dispute, right? Maybe there, in what is happening is that you'll have a core question, maybe one of cost recovery, of profit sharing of the petroleum, right? How the field development decision was taken, and what is the life of that project? because every oil field has a particular life depending on how much oil or gas is available. Now, these are things which naturally lawyers or judges who have become arbitrators may not necessarily have the knowledge to deal with, right? And they're having experts either on the tribunal or experts who are assisting, and maybe as was suggested here by one of the panelists, that maybe Mr. Gupta suggested that maybe we should have the expert actually arguing the matter. And that's quite, I mean, and that's the kind of innovation that we need and we perhaps is happening. You'll find that their inputs are really important in those decision making, because these are questions which you and I also can't answer. And I'll tell you this, I did a year of engineering. I left engineering and then I joined law. But that doesn't mean that I'm an expert, right? It might help me in understanding an engineering question, but not necessarily in terms of giving the requisite expertise to assist the tribunal. Then these are very core questions, like I said. Similarly, I've seen take or pay disputes relating to gas supply agreements. And even there, there are several questions, practical questions that will arise. Right? How is the nomination going to actually work? Right? Are there credible downstream outlets? This could be a question. And then you will find that, there can be question as to, and to show the tribunal what are the mitigation options that are available. These are all practical questions which are not questions of law, but really require expertise in gas pipelines or require expertise in how oil and gas fields develop. So there, now coming back to where India is. Now, I'm assuming when you say India, you're not talking about the private sector, you're talking about government of India. Right? Is that because those are two different, completely the way they interact and they behave are separate. But I think what is happening in government of one thing, that a problem that is there in government of India, of course, is that you'll frequently find that people who may have developed expertise having dealt with these disputes, they're transferred, they're no longer there. So then you don't have the institutional knowledge any longer. So you don't have continuity that assists. This is a big problem. And you don't have sometimes in-house expertise, and they take time. We again, during the discussion, we talked about how, clients sometimes, despite your best advice, will be, penny wise and pound foolish. You can't help it. That's sometimes the nature of the clients. So even though the lawyers and, all of us are sitting here, I think most of us are lawyers, we will sit and agree as to the value the expert brings onto the table. Convincing a client to put that extra money and actually, put your money where the mouth is not going to happen. It's very tough to convince them. And that needs to change across India, whether it's government of India, whether it's the private sector. I think that is again something that's lacking. Government needs to understand the value that they bring, be more forthcoming, try to either be ready to appoint outside experts or at least develop in-house capabilities, and which is not there across the board. So, say railways, they have the experts because they have engineers, they have specific services, and often at least I have not seen it, but I've heard of engineers sitting as arbitrators to decide disputes. But now you don't have that in other sectors, say oil and gas. You don't have continuous experts who are actually doing it. So these are kind of the things that are lacking. But as I said, I think that things are better, and this webinar is also helping towards it. Hopefully, the message spreads, the value of expertise is realized, and we see a better situation going forward. Thank you.
Thank you, Shravan sir. I think that sums up where the, I'll not say India, but where in most of the modern dispute resolution, the uh, the understanding lacks, the technical understanding lacks. So with that, thank you all our panelists, and thank you very much for your valuable insights. Now I'll take like 2 to 3 minutes for the questions of the audience or the participants. If I would request the audience, if they have any question, they can write it in the chat box, and also keep the questions brief, so we can keep it like for 2 3 minutes. I think that will cover it most often. So we'll wait just for 1 minute. So if okay, Aryan has a question, but I would request Aryan if you can put the question in the chat box. Okay, now we have our first question uh, from Prakhar. Prakhar is asking, will India enter into another BITs like it did with the UAE? So I think uh, I would request any of the panelists can give an answer to this particular question, whether India will enter into another BITs like it did with the UAE. Uh, I, from my perspective, I don't think India will.
Happy to answer that, though honestly, that's really not a sector specific question. I think it's off topic. But yes, I think of course this is news available from public sources that India is in negotiation with a number of countries. I think even in the parliament, this there was a parliamentary question in the Ministry of Finance and even the Minister of Commerce and Industry. They've answered this query, and there are several ongoing negotiations that are happening, and we will see India entering into more BITs. Naturally, India is today in a position where it will only enter into treaties which are suitable to it. It is not going to enter into treaties out of desperation. So I think that, of course, it's a time-taking process, but you will find that.
Correct, correct. The next question we have with is Kazi sir. Sir is asking, court-appointed arbitrators are primarily retired judges and lawyers. How the parties select the arbitrators sector specific? I think that would require a specific clause of arbitration where parties should provide the specific sentence in the clause that which specific sector arbitrator do they want. Correct me if I am wrong. If any of
I
the
think I
panel.
think the question rather is that when a party or the parties approach the High Court or the Supreme Court for appointment, what the idea is that usually retired judges are appointed, but the tribunal is of three people. So one of the parties or either of the parties can appoint an expert, and the third umpire who's not getting decided between the two of those nominees can then go to appointment to an arbitrator. But yes, when the issue is of a sole arbitrator, it reaches court, then it becomes a slightly complicated issue whether an arbitrator will be a retired High Court or a Supreme Court judge or an expert. In practice, we've never seen, or either I have very rarely seen any expert being appointed. Obviously, in mediation, we are seeing these days that when a matter is being referred to mediation, they pick up a expert lawyer or a mediator who's doing it part time or specialization. If somebody has mediation, but arbitration, we generally see that if it is a sole arbitrator and somebody reaches the court for appointment, usually they are retired judges.
Correct, correct.
I once heard it in High Court. It was for a sole appointment of a sole arbitrator. The lawyer requested for it was an IP dispute, so the lawyer requested the court for an IP expert to be made an arbitrator. What happened post that, I don't know. But I just heard it that was a request made to the court.
I think court these days are like taking the advices of the parties. I think they have to take the advice of the parties because it is.
So that's why I said I don't know the result, what happened post that. But I did hear the counsel say that, if it could be sector specific.
Correct, correct. I think with that,
If I can add to that, I would say, taking a step back, in fact, what should be the case is parties should realize that institutional arbitration is very helpful there. Then you don't end up going to court, and the institution can appoint arbitrators. And usually, there you'll find that they will appoint more sector specific experts, or at least lawyers or judges who may have a lot of experience in that particular sector. So that is ideally the way forward, institutional arbitration.
I think Shravan sir has rightly said, like, institution do have the pool of arbitrators or the experts for specific sectors such as sports law, arts, and finances. I think that really helps key if the party should go for the institutional arbitration rather than ad hoc. I think with that we'll conclude this questionnaire. I think yes. So thank you once again to all our speakers and to everyone who has joined us today. This discussion clearly shows that the future of arbitration depends not only on the legal expertise but also on the deep understanding of the industries in which the dispute arises. And with that, I would like to invite now Ms. Neha Safi to deliver the final closing remark of the session. Thank you all for being here, sir. I think.
Thank you, everyone. Thank you so much to our speakers and moderator for a very truly insightful beginning of this new journey. Session was so insightful, and we get to know lots of things as a young lawyers who's learning more about arbitration and sector specific arbitration day by day. And thank you to all participants for joining us today. As we conclude this inaugural session of the ADR across industries, we are excited to share what IIDRC has planned for the coming year. This series has been curated to highlight how disputes evolve across different industries and why sector specific understanding is essential for modern dispute resolution professionals. Over the next 12 months, IIDRC will host a dedicated webinar on the first Saturday of every month